Lance Liebman at this point in our careers doesn't need any introduction, and he's not going to get one. But having heard of Andrew, now we know all about the project that he inherited when he became director at the ALI. He got to take on the Restatement of Restitution. And I think a dozen or more years later, he still hasn't shed it. So, okay. Here you are, Lance.
Okay.
I told them I wasn't going to introduce you.
Lionel Smith is not able to be here. Professor McGill in Montreal, he made it to Washington, but did not get any closer than that to here because of travel problems yesterday. So Adam Rigoni, Anthony Dugan, and George Roach are going to be on for us, and we didn't have a meeting about how long everybody should talk, but why don't we say no more than 20 minutes, okay? And less is fine, more is not fine. And Adam Rigoni is both a law student and a philosophy student at the University of Michigan. Isn't that true? Oh, he graduated law school. He is not a law student. He is a distinguished law school graduate and a philosophy student, yes, right? One is a philosophy student for life.
Yeah.
Right? And it never changes from that. You're up.
Thank you. So I should thank Andrew Cull and all the advisory board people for putting together a very good document. I'm going to be critical of it, but steal a line from old Professor mine. I'm critical with due reverence to the source. And I also have to thank Doug Laycock. It seems like everybody's thanking him, but I got to thank him. He was my professor who was teaching the drafts of this when I was a law student, and that got me started thinking about these issues and put me here today. So I'll try to, my main bone of contention is with section 62, which was one of the sections that passed after people stopped caring about what was in it. So I think there's a few problems with that section. I'm going to try to get them out on the table fairly quickly and maybe put out at least some of the claims that I think are controversial, so then you have a chance to tell me why I'm wrong, because I don't think it'd be fair for me to just, pontificate up here without giving you the more controversial claims. I'll try to keep the ones that are actually wrong to myself so that you don't have access to those. So section 62 is the defense that the defendant hasn't been unjustly enriched. And I think there's the main source of tension here derives from the sort of things we were talking about in the early morning section today, actually. So most of the illustrations in this section come from the Moses Manfield decision that's been discussed already at length. And there's this section that was discussed in Professor Wolcher's paper in section 1, where Professor Cull's talking about the movement away from that sort of Mansfield era conception of what unjust enrichment is and the move towards unjustified enrichment. And so contrary to what many of the people in the morning session were saying, I actually think that that movement in section 1 is right. I think what's wrong is the movement in section 62 away from that conception. So in section 62, for example, you see a number of the examples. I think 4 of them are actually taken from the Mansfield discussion in Moses, in the Moses case. And so I think that that in itself creates a tension in the work. Now, does this tension need to be resolved? You might think, well, there's always going to be some tension in a restatement because you're trying to accommodate a zillion cases, and they may or may not all be consistent on almost any plausible reading. And so I take up my methodology, which might be controversial, is I see the restatement as sort of like a best system or a best theory endeavor, where you're trying to match, you want goodness of fit with the data, so the data is, I take it to be like cases and the reasoning therein, and you also want some other theoretical virtues, like you want things to be simple. You don't want the sorts of tension that at least I find in here. And so the question becomes, should the tension, does it need to be resolved? Well, the question is, can you resolve it and get a better theory out of it? And so I think that you can resolve the tension and get a theory that explains most of the data that we have without losing too much. So I go through the illustrations, and most of them I think can be explained on alternative grounds found elsewhere in the restatement, but some of them I do think should just be gone, done, rejected. So, for example, I take up the most controversial ones will of course be the ones that I reject, so let's do those. Illustration 1 is where the guy, he pays the other guy after the statute, or the guy pays the lady after the statute of limitations is run, and the limitations is run on the debt, and he can't get his money back, basically, because the guy who received it has a defense that he wasn't unjustly enriched. And so I went through a couple different attempts, this is in the paper, of various ways to explain it. I've seen it in the case law, it's kind of strange. I've seen it done via statutes of non-claim and statutes of limitation, where they say a statute of non-claim, when it runs, it extinguishes the entire legal, the legal obligation in its entirety, whereas the statute of limitations merely bars the remedy. And I mean, that's sort of out of my wheelhouse. That's interesting, but I don't imagine that that's the sort of reasoning that underlies the illustration 1. I mean, if that is the reasoning underlying it, it's not clear to me from it. And so I thought, well, maybe just like letting A recover, let restitution sort of run roughshod over a statute of limitations policy in some way. Does it like overstep the bounds? And I don't find that argument convincing, because it seems to me that the policy of limitations is aimed at the holder of a claim, and A doesn't have any claim at all until he mistakenly pays the money. So I'm not sure how that sort of justification for the result in 1 would work. And so since I can't find alternative justifications for 1, and I think it sits in this bad tension, I advocate just rejecting it. And I think it also sits in contrast with, and Cole notes this, that it sits in contrast with Section 18, Illustration 7. So that's the case where the court has said that the debt is valid, and then on appeal it's overturned because the statute of limitations has run. And so in that case, it's supposed to be a degree of voluntariness that distinguishes the two cases. So in the case where the appeals court overturns it, the guy can get his money back, but in the case without the appellate court, it can't. And so the justification in that case is supposed to be that, well, because he had a court order, the guy who paid in that case was, more coerced than the guy who was under a mere mistake in the illustration 1 case. And I'm sympathetic to that to an extent, but I'm not sure that that's adequate, because the guy, I mean, it seems to me both people are acting under a mistake. The one guy mistakenly thinks the law requires him to pay the judgment, and so does the other guy. It's just that the one guy's mistake is maybe based on better evidence. But that might be a controversial view of what the law is doing in that case. And then the other illustration that I think that I don't really like the result in and don't think it fits with the rest of what's going on in the restatement is 2. So 2's the two creditor case, and the guy pays 1 on accident, and the other creditor doesn't get paid. And so the trouble in that, what troubles me about that example is it seems like the third non-paid creditor, he's not going to have a claim against anybody. Because his claim against, you might think he had a claim against the second creditor, but that's blocked if the second creditor is in fact not unjustly enriched. So I think that in that case, the creditor who doesn't get paid, he just seems to get hosed, while the second, the creditor who gets the money by mistake, is a rare example of some guy who takes payment and he knows it's made by mistake and he still gets to keep his money. And I can't see a plausible alternative justification. I should tell you, even if you take like some sort of unjust enrichment view, like this still strikes me as the wrong result, just based on like my a priori moral intuitions. So I also end up advocating for the rejection of that illustration. I think the rest of the illustrations can just be explained. Can just be explained by using other aspects of the restatement. Like I think the explanation using the defense in 62 is just simply redundant. So illustration 3 is another like 3-party case where a guy pays the associate a receiver, and then the payment goes from the receiver to the creditors. And it seems to me that in that case that the members, sorry, I lost one place. Well, so the receiver, he's got a defense under 65, and that's noted in the illustration itself. And it seems like the creditors, so long as they don't have notice of the mistake, just are pays for value. So I don't see why you need this rule in 62 to get the result of the illustration 3. And then turning to illustration 4, so this is like multiple parties and they're all confused about this one note that it doesn't say it has interest, but everybody's like intended for it to have interest, and then it gets to the last guy, and the original issuer, he pays the interest and he wants the interest back. And so I think that you can do that pretty easily as just a series of reformations if you reform the note as between the second to last guy and the last guy, and then you can go down the line. I think you might think, well, what if we change the example somewhat so that like the intermediate parties did have knowledge of the nature of the note? I still think you can get it by a reformation between the first and end pieces, but I'm willing to hear more about that if that interests you. Illustration 5, the gambling guy. So he loses in an honest game. This one strikes me as real weird. So he loses his money in his honest game, and he can't recover. But it's even in the parenthetical. The fact that he had a fair chance of winning means he's received counter-performance specified by the agreement within 32.2. So I'm not sure that I think you could probably do it under 32.2. Also, in the unclean hands section, there's going to be a case about a guy who was cheated out of his money in his poker game, and that guy can't recover. So it seems to me that if unclean hands is going to bar even the cheated player out of his money, then it's going to bar the guy who wasn't cheated as well. And then illustration 6 is the Webb-McGowan example. And so, first off, it should be noted that the result in 6 isn't the Webb-McGowan result. So that the result in 6 is just don't give the money back, whereas Webb-McGowan takes a full contractual view that it's not just you don't get the money back, it's that there was an actual contract formation. So it's not clear to me that 6 is equivalent to the Webb-McGowan stuff. Also, 6 sits in tension with 20, illustration 7. I think this has been changed, I'm sure, in the final draft, but it used to be listed as 26, but I think he means 27 in the example. And so 27 is a rescue case related to stuff that's in Professor Wolcher's paper, where the court's going to refuse to compel payment to a non-professional rescuer. And so the idea of distinguishing 6, where they are allowing the guy to keep it, and that illustration in 27 is supposed to be, again, some sort of voluntariness notion. And once again, I'm sort of suspicious of the voluntariness, because I still see them as both being based on mistakes. And so there's something I think that the comment, or at least it seems like from the comments that Professor Cull thinks that the introduction of the court has some sort of effect on voluntariness that makes these okay to reverse in a way that it doesn't. But it's not clear to me what that is exactly. And then I go through, so that's how I would deal. Oh, sorry, I didn't give the answer to 6. So I think 6 can be done with change of position, and that's supported, I think, in some of the case law that's cited in the paper. And so then I go through, and this is sort of the more tedious stuff, I go through the actual cases and try to finesse out alternate readings or slightly different explanations. I can just tell you briefly that I think a number of the cases that look like they make use of this defense have some rhetoric that supports the view of 62, but I think a lot of them involve stuff like waiver, for example. So a lot of the statute of limitations cases actually involve people signing waivers, and per I think it's section 5 of the restatement, the mistake won't bar a waiver or an agreement where the whole reason of the agreement is to resolve uncertainty about this. So when these people sign waivers to like allow the IRS to assess taxes after the statute of limitations has expired, that strikes me as a case where whether the limitations period was in fact expired and all that is actually at issue when you sign the contract. So you can't get out of that just by mistake. So that's how I deal with most of the case law. There's a few other sorts of cases. Explicit waiver in Clifton. I think a couple cases, like I think illustration 2 isn't really supported by the case that's given. So it's given Pensacola versus Braxton. And it's not clear to me that the recipient in Pensacola has knowledge of the mistake. And I think that makes a big difference in between the illustration and the Pensacola stuff. And also one other thing I want to point out, maybe this brings out an important point about the difference between like restatement of contracts and restatement of restitution. So this was discussed, in the lunch period and elsewhere. Sometimes these cases, with especially the statute of limitations one dealing with debts, seem to me to be falling under the restatement of contracts rubrics of antecedent debt as consideration for a new contract. And I think you can do a lot of them under that doctrine if you want to let an antecedent debt serve as consideration. You can see these payments as just like forming a new contract using the antecedent debt if you'd like. But maybe that ignores the real question of whether, I'm arguing that, so you just push that off on contracts, but maybe I'm being unfair doing that because maybe, as was brought up, maybe where that's coming from in contracts goes back to restitution, and you sort of can't have it both ways, where I want to push it off on contracts wants to push it back off on us. So that's...
Adam, let me ask one question. You're a philosophy person as well as a law person.
Sometimes.
I understand. Does, in general, looking at these cases that you're raising these questions about, does your way of looking at it come from an approach or a theme or a theory, different from whether we knew it or not, the way we're approaching it here, and what about the word Andrew just put out half an hour ago, justice.
So do I have like a specific methodology or something that I read cases with? No. So I don't have a full-fledged, like, I'm a economics guy, or I'm a hard positive guy, or I'm a positivist guy, or I'm a hard natural law guy. I don't have a whole lot of commitments that way. I will tell you, so the decision I made when I said, there's a tension here, right? There's two ways to resolve the tension. There's, I think, a way that would be more inclined with Peter and Walcher's views is to say, keep this section. Drop the section 1 stuff. And I haven't I haven't justified. I tend to be inclined to, hey, keep the section 1 stuff, drop this stuff. But so I do have views, but I'm inclined in this work. My goal is just to say, if you want to keep the section 1 stuff, here's an easy way to get rid of the tension, the stuff that's creating the tension, and hopefully, at least, I show that it won't hurt the result in theory.
Thank you. Anthony Duggan, professor at the University of Toronto. It's a great university. On the other hand, when you hear his accent, you'll wonder why his judgment is to spend these months of the year in Toronto. He'd have an alternative, but we're glad he's in North America at the moment.
Question I've asked myself hundreds of times.
I'm sure.
But I'm in Toronto permanently, so your question has even more point. So, years ago, I was having a conversation with my colleagues at the Melbourne Law School about what drives academics to publish. And the consensus was that we all aspire to immortality, and getting ourselves into print is perhaps the only way of achieving this. All well and good until some spoilsport pointed out that most of the library's holdings sit there gathering dust, and most books are hardly ever checked out. So, in the face of that pretty much undeniable truth, we adjusted our consensus to the proposition that for most of this publication is an antidote to despair. But occasionally, a work of scholarship comes along that we know will endure, that will not gather dust, and will be more often off the library shelves than on them. And the Restatement, Third, Restitution and Unjust Enrichment amply qualifies on that front. I think Andrew can be assured of lasting recognition for his leadership of this extraordinarily ambitious project. The Roman poet Horace claimed to have created a monument more lasting than bronze and loftier than the royal structure of the pyramids, that which neither devouring rain nor the unrestrained wind may be able to destroy, nor the immeasurable succession of years and the flight of time. Well, at the risk of seriously overcooking this little tribute, allow me to suggest that the Restatement is Andrew's monument in bronze. And I should add an aside, I suppose. Horace made no mention of also needing a casebook or a treatise to qualify. As far as I know, Horace never had a casebook or a treatise himself. Anyway, my paper is a comparative analysis of the Restatement with English and Commonwealth law on the topic of what English and other Commonwealth scholars referred to as proprietary remedies for restitutionary claims. So this is the area of constructive trusts and equitable liens that Andrew has just got through telling us was the most difficult part of the Restatement. So from my point of view, this is really a case of fools rushing in where angels fear to tread. With that qualification in mind, the paper is structured around 5 simple hypotheticals, each one representing an issue that English and Commonwealth law has had trouble wrestling down. So I'll tell you what the 5 hypotheticals are, so you get a sense of the terrain of the paper overall. But let me assure you, I won't be talking in detail about all of the cases. In fact, once I've gone through the 5 hypotheticals, I'm going to go back and concentrate on the first one. So here they are, and they're all mercifully short. So case 1, Bank A, and this will be familiar. Bank A makes a transfer of $1 million to Bank B by mistake. Bank B goes into bankruptcy before Bank A can recover the money. The payment is still identifiable in Bank B's hands. Can Bank A claim a constructive trust over the funds? Case 2. A is induced by B's misrepresentation to sell Blackacre to B. B becomes bankrupt before A discovers the misrepresentation. Can A rescind the contract? Case 3, variation on the same theme, except this time the subject matter is money rather than land. A is induced by B's fraudulent misrepresentation to lend $500,000 to B. B banks the money but becomes bankrupt before distributing any of the funds and before A discovers the misrepresentation. There are no other funds in the account. Can A rescind the loan contract with B? Case 4. A engages B, a real estate agent, to purchase a commercial property on A's behalf. B purchases the property for himself at a price of $500,000, concealing the purchase from A by telling him that the vendor has changed his mind about selling. B goes into bankruptcy. Can A claim a constructive trust over the property? And case 5, which isn't strictly a restitution case, but it's relevant to the property thing, goes as follows. A and B enter into a contract for the sale of Blackacre. A pays 30% of the purchase price on the signing of the contract. B becomes bankrupt and B's trustee refuses to complete the transfer. Question, can A sue for specific performance? So they're the 5 cases, and they all have a notable common feature, which is that if the claim succeeds, the disputed asset ends up being subtracted from the bankruptcy estate and goes to the claimant, goes to A. In other words, the claimant's claim gets satisfied in full, and the estate is correspondingly depleted so that the other creditors get less. So turning to case 1, the mistaken payment case, as the restatement tells us, the US courts have long taken the position that in a case like this, Bank A makes the payment by mistake to Bank B. In a case like that, A is entitled to a constructive trust over the money in B's hands, provided that the money remains identifiable. And English and Commonwealth law, turning to the outside, is a little sparser on point, but it tends to the same conclusion. So the question, though, is why should the mistaken payer have priority over the defendant's other creditors? Why, in my little scenario, should A be paid in full if the consequence is to correspondingly deplete the estate? In other words, what makes restitution claims special in bankruptcy? Well, the stock response to that, and this is repeated again and again in the case law, is that the money doesn't belong to B, and so it shouldn't go into the estate. Well, that's circular, because A's claim to the money depends on the constructive trust. And so you can't justify the constructive trust by saying that A has a claim to the money. So then another response is to say that A is an involuntary creditor, meaning that A never intended the transfer, and so it did not voluntarily accept the risk of B's bankruptcy. This, so the argument goes, makes A different from ordinary creditors, lenders, trade suppliers and so on, because ordinary creditors do accept the risk of B's bankruptcy and they compensate themselves for it by making upfront price adjustments and that sort of thing. So since A is different from the ordinary creditors in that sense, it deserves priority over it deserves priority in B's bankruptcy, or so the argument goes. But then you have to ask, what about tort claimants, for example? A person with a tort claim against B is an involuntary creditor in the same sense, but we don't give tort claims priority in bankruptcy. So we still haven't answered the question, what makes restitution claims special? Well, at that point, the usual move is to say that A's claim rests on not just one foundation, but two. The first is A's status as an involuntary creditor, and the second is the proposition that the other creditors would be unjustly enriched if the money stayed in the estate. Well, that, or something close to it, is the position that the restatement takes. The restatement puts the second proposition in terms that a debtor, or a bankruptcy trustee, which comes to the same thing, should not be allowed to rob Peter to pay Paul. But the robbing Peter to pay Paul characterisation assumes that the money belongs to Peter in the first place, so we're right back where we started. So another concern is that the voluntary creditor, involuntary creditor distinction is indeterminate, at least in some factual settings, and that means it's likely to promote litigation. Particularly in the bankruptcy context, rules that promote litigation aren't a good idea, because by definition we're dealing with a limited pool of resources, and the more we spend on litigation, the less there is for the creditors. Let me give an example based on a leading Canadian case. So I should hasten to say that this case is not a mistaken payment case, but that point doesn't matter in terms of the lesson I want to draw from it. So what happened was that a dealer sold and delivered a truck to a customer on condition that the customer would arrange finance. Well, the customer failed to arrange finance and went into bankruptcy. The dealer claimed the truck back from the trustee, and the case found its way to the British Columbia Court of Appeal. The court found for the dealer on a pretty straightforward basis that the contract of sale was subject to a condition precedent, namely that the customer would obtain finance. That condition was not fulfilled, so the contract never came into existence. Well, that should have led to the conclusion that title to the truck remained with the dealer throughout, and so the truck wasn't part of the estate. And if the court had stopped there, that would have been great. But for reasons that aren't entirely clear, the court assumed that title to the truck had passed to the customer, and to remedy the situation, it made a constructive trust order in the customer's favour. So it held that in the dealer's favour. So it held that the bankruptcy trustee held the truck on constructive trust back for the dealer. The leading judgment relied on the voluntary creditor, involuntary creditor distinction as a basis for justifying constructive trust relief in the case. So here's the key passage. So this is the leading judgment. Hallmark was the dealer. Hallmark was imprudent in allowing the truck to leave the lot as it did, but it accepted the risk in the interest of good customer relations that it may have to take back a used truck if financing fell through, and in that event it would not be able to recover the depreciation. Ellingson was the customer, Ellingson induced Hallmark to believe that he would be able to meet the bank's cash requirements for the loan, and so Hallmark waited the 3 months before bankruptcy occurred. In other words, according to the court, the only risk that Hallmark accepted when it handed over the truck to the customer was the risk of loss through depreciation if the deal ended up falling through. It did not voluntarily accept the risk of Ellingson's insolvency. Why? Because Ellingson had lulled it into a false sense of security. Okay. That was the court's story. That was the justification the court gave for saying that the dealer deserved special treatment in Ellingson's bankruptcy. The problem for me is that that story, that version of the facts, is contentious. A different court might just as readily conclude that Ellingson's conduct did not negative Hallmark's consent, that Hallmark was a relatively sophisticated commercial player, and that in releasing the truck to Ellingson, the customer, it must be assumed to have accepted the bankruptcy risk. Now, of course, that view of the facts is no more necessarily correct than the story that the court told. The point is that in advance of the case, it'll be hard for the parties to predict which way the court is going to jump. Unpredictability means uncertainty, and uncertainty means an increased likelihood of litigation. So the bottom line is that in the bankruptcy context, more for the lawyers and less for the creditors. So I'll leave it on that.
Just one question about Madoff. You can't come to the United States. One second. In what Andrew rightly calls the clawback stories, why shouldn't we just say everybody who gave them money, as far back as we can go, should try to give them back the same percentage? Why leave it with the people up to the extent they are only getting back what they put in?
Mm-hmm. Well, I have no quarrel with monetary compensation in these sorts of cases. So the issue is not whether the dealer in the Ellingson case was entitled to relief. The question, which has particular salience in the bankruptcy context, is whether they're entitled to proprietary rights.
I understand.
Yeah. I'm not sure how that's engaged in the Madoff context. So you're really talking in the Madoff context about some sort of pro rata sharing.
Yes. But shouldn't everybody be in the same situation, regardless of whether they got a check back at some point?
Right, yeah. Well, in principle, that sounds right to me.
Maybe.
But that scenario is really the opposite of what I'm talking about.
I understand.
My problem is the one where someone is preferred over everybody else.
I agree. Victor?
Just a quick question on this Hallmark Ellison case. If the title didn't pass, so if the dealer still owned the truck and the buyer had an accident, would the dealer be responsible in Canadian law for that?
The default rule, I think that the Canadian sale of goods legislation would be similar to the Uniform Commercial Code on this. That the default rule is that risk goes with property, so that unless the parties had specified something to the contrary in the contract, the dealer would be at risk. Whether there was some such specification, I don't know.
So it's the one risk you left out of the allocation of risk.
Yeah, but it didn't sound like this dealer was thinking very clearly at the time.
Thank you.
Could I,
Yeah, sure.
could I just intervene here to say, I think Lance's question is more pertinent to Tony's discussion than Tony has quite acknowledged. I mean, the basic Madoff situation that we're talking about is everybody accepts, it seems, that A and B, or well, A, B, and 100 other people have all invested just the same amount of money, and the first ones, the lucky ones, let's say they got back exactly what they put in, just by good fortune. And then musical chairs stopped, and nobody else, everyone else is fighting over what remains. The assumption is, if you are fortunate enough to get back what you paid in, you get to keep it. I mean, that's
If you got more, just for everybody.
if you got more, then you
got to
get
give
back.
that back.
Let's just say you just got back exactly what you paid. That is the assumption. It does raise the question of why are we giving these people an effective priority? They are exactly similarly situated, whether as voluntary creditors, defrauding creditors, whatever they are. Everyone's exactly the same. It is an effective priority. I would have said the traditional answer is you can't answer these questions without saying, as Justice Jacobs said to me last night, at some point you have to say, well, there's this idea of equitable title, and it's a matter of getting back what is yours. It never stopped being yours, and at least to the extent of the equitable interest. And I would have said, this is the in the ordinary commercial situation. If you give what you quite rightly call a priority, it's because at some level the law says, well, it never stopped being his, and he's getting back what's his, and we don't treat him in the same. You understand what I'm saying?
I understand what you're saying, but then how do you address the question begging charge? To where does the your argument rests on the proposition that at some level the money still belongs to the transferor, but where does that proposition come from?
Well, I mean, how much of I would say the traditional. I would have thought you would tell me in Canada and England also, how much of the traditional conception of equitable interest in property. They used to talk about, this is an example of what lawyers used to talk about all the time, and everyone accepted it as gospel. Our dual theory of property law, legal and the equitable. How much of it do you want me to start justifying? I mean, for a long time, it's a way of thinking about it. And I could explain why in some situations do we regard an equitable interest as being retained and others not. Mistakes, frauds, yes.
Yeah.
I mean, where do I have to start? Yeah. I mean, you know what I'm talking about.
Yeah. Sure. So my take on this is that a lot of it is time related, right? So we no longer question the existence of equitable proprietary interests in land. We don't question that specific performance gives the purchaser immediately as sale is concluded has a right to specific performance. We don't question the proposition that the mortgagee has an equity of redemption, which is a proprietary interest. But my take on that is that these situations have been frozen in time. So much has happened. There's so much accumulated case law that it's now too late to go back and say this is wrong. It's at least too late for the courts to go back and say this is wrong. But what's interesting about the constructive trust is it's constantly engaging new fact situations where the courts don't have the advantage of centuries to fall back on. And when you get a relatively new situation and you're invited to find a proprietary interest, I think you're forced to openly engage with the underlying policy considerations and to ask yourself the question, what does make this claim special?
Please.
I don't want to just suggest that I teach bankruptcy law too, on occasion at least. And the claims that the trustee is making in the Madoff case, of course, arise under the bankruptcy code, which for recovered fraudulent transfers has a 2-year statute of limitations. The bankruptcy trustee can also ride on state fraudulent conveyance law, which typically has a 6-year statute of limitations. These transfers, many of them received were far more than 6 years ago. So again, people get to keep those simple because that's all.
That's just an arbitrary subject.
So, but to the extent they occur within that time, the extent they repay what they received under any theory, they get a corresponding claim pro rata with everybody else in the suit. So often the settlement will be netting that out, so they pay a sum, and they get no distribution, so they take that into account when they make the sum.
Okay, thank you very much. Now, George Roach, his degrees from 3 great universities, Davis, Harvard, and the University of Texas. And seems to be, best I can tell from what's described here, an interesting and complicated professional life, right?
Yeah, I sort of consult on damages strategy. And right now, at least in Texas, I'm sort of doing missionary work on Unjust Enrichment because it's sort of a lesser-known remedy in Texas. You all had King James, Henry, and Elizabeth in your heritage, and I'm afraid we were stuck with King Philip. So I think that's a big part of our disadvantage. Texas has 3 things to be humble about. Jerry Jones owning the Dallas Cowboys, ice in the winter, and Unjust Enrichment. And you know, I'm sort of a cheerleader on Unjust Enrichment and restitution. I would hasten to point out that as the economy is being transformed from a smokestack industry to a data industry, there's no other remedy that's going to deal with that. I had a case 2 years ago on virtual game players. You know, people have these elaborate games on the internet, and there was a cause of action for, I think it was conversion, for stealing their asset that they had won on the game, and whether or not they had a right to supply third-party sources for these games. I mean, what other kind of law is going to be able to deal with that? We have unjust enrichment is the only area that can deal with things like negative information. What is negative information? It's information you've accumulated on things that don't work. You know, Edison had to go through 1003 or 2003 versions before he got the light bulb. Well, imagine if the competitor had come in and stolen the information on the first 1002 that didn't work. Well, we had a court out in California that said, you got to pay unjust enrichment of 3 years of the costs that were taken to acquire that negative information. So unjust enrichment and restitution is essential as we get more and more into the virtual asset and the intangible asset economy. I'm here to talk to you today about counter-restitution. And by counter-restitution, I mean the offsetting credit for revenue apportionment and offsetting beneficial expenses. Palmer called it the manifestation of the law's commitment to total equity. And I think it's very important. I believe my article shows that there's adequate support for the proposition that the defendant has a right to counter restitution, subject to existing exceptions and conditions. The restatement first and third of restitution limit the use of the term counter-restitution to rescission, but you discuss the substance of counter-restitution in numerous sections. The restatement third proposes to deny counter-restitution in case to defendants of fraud. I think I can show that that is not substantiated under current common law, but I'll get into that. The more worrisome area involves the advent of a new group of users of restitution and unjust enrichment that I think are rather abusing the remedy, and that's the FTC and the FDA. They secure remedies in equity that deny counter-restitution as a matter of law. Now, this isn't just transaction costs. We're talking about business operating costs. They come in and claim the remedy of restitution, and they demand the defendant's total revenues. It's not just adjusted for labor costs or anything. It's total revenues. And I don't think there's any precedent in that for that in traditional equity or really any reasonable standard for equity. Under Grupo, the Supreme Court would limit them to equitable remedies as of 1787, but I don't know that we have to limit to that, but it would apply to any standard. The other thing that the Supreme Court does is it sets up the restatements as an arbiter of what is a traditional remedy in equity. And I think the other thing to be gathered from this, especially in the FTC and the FDA, is it appears that some of the federal courts are ignoring the restatements. For the purposes of the article, I use the term gross disgorgement to refer to the measure of unjust enrichment without offsets for counter-restitution. And in this case, I'm not talking just transaction costs, I'm talking business operating costs. Disgorgement by default means that the defendant has an opportunity to prove his counter-restitution, but he produces insufficient evidence, it's not found relevant or whatever. Notice, he has the opportunity to prove it, and he fails to prove it. The problem in a lot of the cases that I've seen, especially in the FTC and the FDA area, is a failure to distinguish the two, and having to do with the right to try and prove counter-restitution. Because I think there's a big difference. I go back to the 1872 Supreme Court case of Mowry versus Whitney, had the classic definition for me of unjust enrichment, which focuses on but-for, a but-for measure. The question to be determined in this case is what advantage did the defendant derive from using the complainant's invention over what he had in using processes then open to the public. It is an alternative standard. It is a but-for standard. And it's almost uniquely American. For example, we allow for negative enrichment. The British, for example, do not, and still do not. If we go back to the 19th century case of Root versus Lakeshore, that was when the Supreme Court held that a plaintiff's remedy should be measured as if the defendant were a self-dealing trustee. It's a strong concept, but it took, at least for me, it took Judge Geiger's opinion in 1824 to clarify it. What he said it means that we treat a defendant in a case of unjust enrichment no worse than we would treat a trustee in default. So let's look at the trust standards. Section 244, the Restatement Second of Trust, provides that the trustee's indemnity survives a breach of trust if the expenses benefit the trust, even if they weren't authorized under the trust. Comment C of Section 403 of the Restatement of Agency is opposed to that. It provides that a disloyal agent who profits improperly may not deduct the amount of expenses. On the other hand, that's contradicted by Section 439 of the Restatement of Agency. It's also interesting to look at the modern standard of indemnity for the trustee's services. I think the Restatement Third takes a position that for willful, conscious, unjust acts, the defendant is not entitled to compensation for services. I think the more modern standard is a little bit more flexible than that. And I offer as proof of that a case in the Texas Supreme Court against a lawyer's breach of fiduciary duty. Certainly there shouldn't be any higher standard than that. And they said that it's a mixed question and that they want to look at a number of factors, which suggests to me that a defendant, normal charge of unjust enrichment, should have that right to prove counter restitution. Texas Supreme Court notes, by the way, that at least 18 states hold against automatic forfeiture for the trustee in breach. The restatement's rationale for counter restitution, I think it has three major rationales, at least as evidenced in Section 51. There is the benefit standard, which is acknowledged and frequently honored. The Section 51 also talks about the priority to avoid a punitive remedy. And third, the doctrine of the officious claimant. I should add that public policy is always a consideration involved. Counter restitution is always conditioned on evidence of public policy. Just as the trustee must substantiate any claims for indemnity, the defendant has the burden of proving all offsets for counter restitution. A couple of years ago, I looked at about 116 IP cases, and where the defendant had failed to produce enough evidence to prove his counter restitution. It's interesting that in 60% of those, only 60% of those cases, the court awarded revenues. In the other 40%, the court came up with some proxy for the expenses. At present, the federal and Second Circuits have a rule that require the court to estimate a defendant's counter restitution, even when he can't prove it. There are obvious exceptions on counter restitution, largely involving property issues. A misappropriation of real property. We get into the issue of capital improvements. On personal property, the specific restitution trumps counter restitution. And then we get into the famous issue of trespass to minerals. I wish I could claim it's just specific restitution. It's not. It's public policy. Woodenware is one of the more famous trespass to minerals cases. The U.S. Supreme Court held that we shouldn't provide the defendant with counter restitution because it would be against public policy. And then I found a cite to some of the old English cold cases that were used as justification for the misappropriation of minerals, and it was admitted, at least in some of the cold cases, that the judge just wanted to punish the defendant. The third restatement proposes to deny a fraud, fees, or counter restitution. I think what you mean by that is the transaction costs, but it's something to look at. Palmer and Dobbs are opposed to that. Illustration 23 of Section 51 of the third restatement advises that the fraud feeser should receive no counter restitution, even for necessary expenses. Two of the three cases cited by the restatement third were default disgorgement cases. Ward versus Taggart, and I don't know how to say the other guy's name, Listoke. They were default disgorgement cases. Either they couldn't prove their expenses or they didn't have expenses to prove. But the court didn't say that they didn't have a right to counter restitution for the fraud. There's also existing cases from the federal and Fourth Circuits that hold that a fraud feeser is entitled to counter restitution. I do think a distinction needs to be made between transaction costs and business operating expenses. Dobbs provides for that distinction in his treatise. And I'll note that the third restatement does allow for counter restitution for business operating expenses in illustration 24 in section 51 and illustration 7 and 8 in section 43. So there's a contradiction there that could at least be explained, I think, by the distinction between transaction costs and business operating costs. The FTC and the FDA jurisdiction and equity is based on implied jurisdiction. It goes back to Stevens versus Gladding in 1858, when the U.S. Supreme Court held that the plaintiff having filed a plea for an injunction, he was automatically entitled to unjust enrichment without further pleading. That the unjust enrichment was just an ancillary claim where he had implied jurisdiction for it. Advanced to the 40s of the Porter and Mitchell cases, which had to do with federal agencies, and they were the foundation for Texas, the SEC versus Texas Gulf Sulfur, which of course was the basis of the SEC claims until 2000. Only after 2000 did the SEC have any specific statutory authority for unjust enrichment remedies. There have been also a number of other federal agencies that have used unjust enrichment as ancillary to their injunctive relief, including the Department of Energy. The SEC and the CFTC allow counter restitution. That's never been seriously in doubt. And if you look at the Texas Gulf Sulfur case, the opinion from the Second Circuit there strongly endorsed avoiding punitive damages. Let's look at one of the FTC cases. This is not true in all cases, but it was true in this one. It's sort of indicative of where they're going. Stefanczyk was a scoundrel, like most of the defendants are in the FTC cases. These are not nice people. You wouldn't want to break bread with them, and you sure wouldn't want them to be around your family. Stefanczyk had a get-rich-quick scheme of helping people or trying to teach people how to make a lot of money by investing in subprime mortgages. Not a very good idea. But he had this book and he had a handout, and it was sold through a separate company called Atlas. And Atlas paid Stefanczyk about 20 to 25% of royalties on what they sold of his goods. The Ninth Circuit came in and affirmed the opinion that said that we're going to define unjust enrichment not as Stefanczyk's revenue even, but Atlas's revenue. Saying that because the FTC Act is designed to protect consumers from economic injuries, courts have often awarded the full amount lost by consumers rather than limiting damages to a defendant's profits. This is on the basis of statute that says the FTC is entitled to seek injunctive relief. Not anything else having to do with the FTC Act, just injunctive relief. Just as Stevens versus Gliding was just about injunctive relief for patents. Stefanczyk demonstrates three key issues that are brought out. There's an extraordinary amount of confusion between restitution, unjust enrichment, and disgorgement. Much like Paul Penniman talked about, I think, the tobacco settlement. Wasn't it called Smoke Gets in Your Eyes?
Yeah, it's been...
There's a common held belief that restitution is a more encompassing remedy than unjust enrichment or disgorgement. Don't know where they got it, but that's what they believe, especially in the Ninth Circuit. Second, the Ninth and other circuits believe that they have the authority to order consumer redress or reimbursement under the FTC Act. Again, based on strictly injunctive relief. And third, the Ninth Circuit and other circuits have openly held that equitable remedies can be punitive, despite the obvious number of precedents from the Supreme Court that hold otherwise. In an FDA case, the Sixth Circuit denied counter restitution by evoking sympathy for the consumer. Appellants who disobeyed the law should not have his expenses covered by consumers. To say that restitution is unavailable is to say that consumers must cover the costs of appellants' production, advertising, and illegal distribution. Redefining unjust enrichment on the basis of sympathy for the victim. The FTC now has gone a step further. They no longer require willful actions or intent. They can make these claims now against negligence. These cases illustrate that businesses can cause direct consumer harm as contemplated by the FTC Act in a variety of ways. In assessing that harm, we look, of course, to the deceptive nature of the practice, but the absence of deceit is not dispositive. This is for holding direct liability, not aiding and abetting liability, direct liability. it would be nice for the courts to be able to claim that they were confused. The question is, did they try and find out anything? Did they try and seek out any authority? Nope. There are 869 federal cases that mention the Federal Trade Commission as a party, and 655 federal cases, the last 20 years. The CFTC, they mentioned the restatements once in all those cases. Palmer and Dobbs are only mentioned once also. They're not seeking the restatements, I'm afraid. And it's growing. The FTC and FDA are expanding the application of their doctrine for measuring remedies and equity. There are already a few cases outside the federal agency litigation that cite the agency cases for their definition of what unjust enrichment or remedies and equity are. The FTC has announced plans to initiate disgorgement remedies in antitrust cases. The FDA has secured a number of huge settlements for pharmaceutical companies for violating manufacturing standards. One settlement was for $400 million. You know, if you go back to the Elizabethan age, this would be the equivalent of the king's minister in the king's court going against one of the king's subjects. How do you think it's going to come out? And that is what's happening here. If and when, now, as I recall from last year, the FDA bill to approve their jurisdiction over the food industry did not pass. But they would have extended this to the entire food industry. I think what we have is a case of bad facts make bad law. The denial of counter restitution is sometimes justified by the defendant's bad acts or their victims' losses. The problem is it's likely that the equities prohibition of punitive damages would be weakened and that the agency case exceptions would further expand beyond any clear boundaries. Given the wide latitude inherent in equitable discretion, judges in equity occasionally awarded remedies or measured remedies in a manner that resembled punitive damages. Oh, is it? I'm sorry. I think the point here is that when you get beyond the outlaws, and we can talk about Andy Cole's article on outlaws, the problem here is that when you allow for these exceptions, what will happen is that the boundaries of their special definitions of the remedies will be limited only by their ability to find cases with bad facts. And it becomes undefined. And it's sort of beyond the realm of the restatement. Thank you.
Well, we have some time and some questions. Jack.
This is directed to Professor Roach. Just one comment, and then the question that I think most of us are asking is the consequence of what you just showed us.
Now, the people in the back.
Okay. For those of us that have grown up schooled in traditional equity, what you call counter restitution is almost gospel. Certainly in the corporate law, corporate fiduciary area, the Guthrie Loft is a perfect example. You have an executive who dominates the board of directors of Corporation A, uses Corporation A's assets to acquire the rights to the Pepsi-Cola name and secret formula, funds a company using Company A's assets, and then grows it to be a multi-million-dollar corporation. At the end of the day, his stock in Pepsi-Cola is subject to a constructive trust, in favor of Corporation A. He's got to pay back all of the salaries and dividends, except for a reasonable salary that would be paid to an executive to do exactly what he did in a market transaction. That's the counter.
Brooks versus Constant.
Right. Now, you do cite some exceptions, one of which is trust law, which has always been much more harsh than, the ordinary fiduciary law. And cases where courts have said, we're just not going to apply traditional equity principles because of public policy considerations. I understand that. Once you take those out of the picture, then you still have traditional equity being applied. And I guess the question is, how is it that the FDA and the FTC are distorting that without any apparent congressional authority? And why are the courts allowing that to happen?
I can think of 4 or 5 articles in the audience, represented by authors in the audience, to talk about confusion and misunderstanding and lack of education on the terms. This is it coming home to roost. They literally say things like, we couldn't award this remedy in disgorgement, but we can award it in restitution. I mean, that's sort of nonsense. That's sort of gibberish. But this, you're talking the 9th Circuit, the 10th Circuit, the 11th Circuit, and God forbid even some of the 7th Circuit. Now, I will tell you, the FTC is very wily. They select their venues very carefully. More than 50% of their cases in the 9th Circuit and the 11th Circuit. You can count on the fact they're not going to go anywhere near the 3rd Circuit for the extra expertise in that area in matters of equity. They avoid the 2nd Circuit. In fact, the 2nd Circuit is getting to be sort of the saving grace in their opinions in Kavanaugh and Verity. But I mean, it's probably going to take a Supreme Court opinion because the FTC is just raring to go. They have totally turned around their notion of administrative law. You can go to their website and they say, boy, after we figured this out, this work, we've recommitted our resources in administrative law into litigation. It's a lot easier.
Doug?
I don't know these FTC and FDA cases except for a couple of them, but which I thought were outliers. I didn't know there were a whole series of these. And I'm certainly not trying to defend the courts, but I wonder if what's going on might be something like this. If I've got a scheme to sell worthless advice for big money, all the consumers who buy my worthless advice get nothing in exchange. They're out everything they pay. So gross revenue is not a bad measure of compensatory damages. And those consumers could sue me one at a time, but of course they don't. The FTC is operating under a statute that apparently doesn't give them authority to seek damages. And the judges think what they're doing here is providing compensation under the guise of an unjust enrichment theory, and restitution as a word sometimes gets used to sort of mean put the plaintiff back in the position he started from, which is compensation, not restitution as we use it in the restatement. But I wonder if that might be why they say this isn't a disgorgement remedy, but it's a restitution remedy, and what they really mean is it's compensatory remedy.
I'm sorry. There are 2 provisions in the FTC Act. One is that allows for injunctive relief, and that is Section 13. Section 19 allows for specific remedies, including consumer redress. But that requires a much more elaborate process. It's an administrative process, and then is open for appeal. So that they have specifically chosen to avoid their own consumer redress for injunctive relief, and they're pursuing a loophole. The second thing is, I certainly grant that after the defendant goes up to defend his counter restitution, he may not have anything to prove, but at least he has the opportunity to prove it as total equity. The defendants now are being held by motions in limine that they can't even produce evidence about the counter restitution. And you know, again, these aren't nice people. But how's that going to affect the rest of the law? How's it going to bleed out and affect other cases that are on the margin? I mean, we saw that happen in Blake, for example, on how that's affected British contract law, and that was very deliberate, and it was a choice on their part. But generally, it hasn't. In the outlaws really haven't affected the law that much. They've been sort of isolated cases, but this is a risk here of having a major impact on the law.
Good.
What Doug's question, isn't it, if this were brought as a class action, and I was the wrongdoer was supplying something totally worthless, the consumer would go for their money back, like the normal remedy. And isn't that the remedy that, in effect, the FTC is doing? Money back without any
That's,
And then the consumer got zero, therefore the class action would give exactly what you're talking about.
but they're trying to convert a remedy in equity into a remedy in law of seeking compensatory gain or looking for the victim's loss rather than the defendant's gain. And they're free to go after consumer redress under Section 19 in the FTC, or they could file a more standard claim at law, but they're going through this loophole of an ancillary remedy to injunctive relief, and they're sort of stuck with it. The other thing, by the way, that they could do is do a mass action for rescission, which I think is the cleanest version, and there you get into the worthless issue of, the Sixth Circuit case of these arthritis treatment things that were sold for $89 that were worthless. Well, fine, they just prove, all the FTC has to do is prove they're worthless, and then they do get gross revenues. Although they don't get the revenues that an intermediary receives rather than the defendant themselves.
Other questions, or for any of the speakers on this panel?
If I may just chime in on this conversation, I'd like to say, I think the cases that George Roach is talking about, it's very interesting. I think, to me, Doug Laycock's response is totally sympathetic. It is a explanation of the phenomenon. It's a suggested way of explaining what's going on here that would be very consistent with what we see happening in many other places. Of course, I agree with you that it's deplorable for the future, well, at least for the use of the word restitution. It's a shame we can't get rid of the word. But I would just wanted to throw in here that this question of the availability of counter restitution, which you're quite right, we did not use the term systematically, but you're also right, it comes up and up and up. As I think back, this is one of the few issues where there's a real difficulty in the law. It's not easy to explain certain contrasts in the decisions. It was something that was raised early, middle, and late in discussions in different meetings with advisors and members, and we never solved the problem, although we suggest a couple of reasons. It seems to depend to a great extent on what is the nature of the assets that are the subject of the underlying restitution claim. What's the nature of the benefit that has been conferred that would ground the claim in counter restitution? The two polar examples, I wish I had known that there was this feature of the, how do we call it in Delaware? Goof?
Guffey law.
Guff. I wish I'd known it had that feature because we ought to have that citation. But equally, if not more famous, Beatty versus Guggenheim, is that correct? If you, in breach of every duty of loyalty, take somebody else's, abuse your position for personal gain, and we catch you with the mining shares or whatever, of course you're going to be held as a constructive trustee. But I'm not aware of any case in the entire history of the thing where you will not be entitled to recover the money that you laid out in your attempt to obtain these things in your disloyal, criminal attempt to obtain these mining shares for yourself. Conversely, at the other extreme, if what you've been doing is stealing the plaintiff's timber and turning it into shingles or the various things that cases are about, I'm not aware of a single, and as a conscious trespasser, not a innocent one, I'm not aware of a single case that allows you a nickel for the value of your work in cutting down this, where 98% of the value of the shingles is your labor. So there's these polar extremes. And the only reason I mention it is, as I say, at every stage of this project, over 15 years, people were saying, this doesn't make any sense. Why don't we resolve it? You're writing the restatement. Why don't you fix it? And my attitude was, this is the way it is. We have to describe it. We have a couple suggestions why this might be, which some people like and others don't. But it's a good puzzle. It's still sitting there.
Well, a big part of the problem is that a lot of the opinions or the actions that are taken by the courts in this area are not published because it's like motion practice in constructive trust. they don't make the books very often. For example, it's been long held that Snap didn't get any counter restitution in the CIA case. He did. He got counter restitution for his income taxes. But you have to read his book, Irreparable Harm, to find out, because there's no opinion out that deals with it. And these things are very hard. It's very hard to collect the data unless you go through the New York Times or that sort of thing. Tony?
Just a question of detail. I'm curious. So on the Beatty and Guggenheim scenario, do U.S. courts follow the Boardman and Phipps distinction, which says that if the fiduciary breach is innocent, then they're entitled to recover their inputs, but if the fiduciary has acted with actual fraud, then they're not? Is that distinction maintained here?
Well, I didn't think it was as a matter of fiduciary law. You know, so Professor Cull gave me some, what he says are counterexamples. Maybe Delaware's law is different than New York's.
I'm not sure what you mean inputs. I would have said, so far as my knowledge goes, if the input is you laid out cash in order to buy the asset that is now being recovered by your principal, you're going to get it back, every cent. If the input is, well, I'm entitled to some the value of my time. Look what I did, and look at the wonderful profit you're now making. I would expect those decisions to turn clearly and decisively on the question of am I innocent or blameworthy.
Now, you are aware that the illustration in Section 51 runs counter to what you just...
In the Constant case?
Yeah, no, it wasn't the Constant case. There's an illustration, I'm sorry, it was illustration...
We can fix it in the fourth restatement.
It's illustration 23 of Section 51.
Isn't that the Constant versus what's his name?
No, I don't think that was Constant.
Oh, well,
Constant was something very different.
Well, we can argue about it or look it up later. Any other questions, or we're going to thank these panelists and move to the last panel?